Yes. Yes.
Umepata mtu from anybody from Kapengo?
Process amepikiwa.
Yes.
Ngoja wapikia wakuje. Wajeni.
Prosecution.
Yes. Yes, Langat nakusikia.
Mambo
Poa.
inapata sasa.
Yeah.
Ile imekuja
Imekuja sasa hivi. Imekuja malinda hapa naenda kutorea.
Kumwambia
Hapo sawa. unajua yeye ndiye alikuwa ameniambia watafunza something
Es bueno. No,
Sema kondom ya mdomo. Nitakupatia polisi mmoja. Reng. Ni aje Rotich. Mwambie tuko Central Police. Mjafika. Lakini ni mweshi tu ataingia pekee.
Yes, he was not present.
Leta. Kianza, sindio? Ikianza kama ikae tu.
Prosecution.
Yes, Your Honor.
You are ready?
Yes, Your Honor.
Yes, Your Honor. Yes, Your Honor. We are very ready. Can you mute? Unless you are getting mute your mic. Are you ready? We are ready, Your Honor. We are starting with miscellaneous for the Honorable Sudi. Okay.
Court proceeding now starting. Bro.
Can you hear us?
Yeah, you can hear.
Mheshimiwa.
Yes, nakusikiza.
Wakili wako wako hapo.
Yeah, wakili wako.
Yes, you want to be present?
Name of the counsel.
Your Honor, I have a list of my team. GB Cholet. Okay, you comment? Terrell Isaac. Nathan Chorore, Kikwet Ngetich, Jen Masai, Collins Kiprono Collins. Kiprono Collins. Kiprono Collins. Karori Oliver. Collins. Karori Oliver. Karori Oliver. Manasseh Tunet. Manasseh Tunet. And myself is Hilary Sigay.
If you don't mute, we are going to exit you from this session. Please. Unless you're talking, would you please mute your camera? Jessica?
Oh, Your Honor, there's too much noise.
Yeah, mute. You're not muting everyone. All right, Mr. Sigay.
Yes, I was concluding saying my name is Hilary Sigay, and that
Yes, I got the lawyers for the accused, for the suspects.
yes.
Madam Prosecutor.
Morning.
Morning, how is
For the Republic.
Yes.
And I'm ready to proceed with the application.
This out.
Yes, Your Honor, I have served.
Mr. Sigay, have you been served with the application?
Yes, Your Honor, we've just received the application here at the station
Yes.
some 10 minutes ago, and we are ready to deal with it if the prosecution is ready to proceed with the application.
Yes. Mr. Karole, proceed.
Much obliged, Your Honor. The application is brought under Article 49, 1F and G of the Constitution and Section 36A of the Criminal Procedure Code. Your Honor, the Republic is seeking to detain the respondent, Oscar Kipchumba Sudi, for 14 days at Nakuru Central Police Station to enable the applicant conclude his investigations. Your Honor, the application is founded on the provisions of the law aforementioned and the affidavit sworn by Inspector James Akelo, and the following grounds. Your Honor, the police are investigating the respondents for the following offenses committed by him. Number one is hate speech, contrary to Section 13(1)(a) of the NCSC Act. Number two is assault of a police officer.
That one is contrary to section.
Contrary to Section 103(a) of the National Police Service Act. Number three is offense report act. Contrary to Section 94 of the Penal Code.
Have we lost you?
Okay. Sorry, I think it was the internet.
Okay. So let me connect you to the person on the ground because I'm
Mr. Karori?
Yes, John, I can hear you.
Yes, proceed. Your last point was unlawful possession of fire and ammunition.
And yes, contrary to section 89(1) of the Penal Code.
Yes.
And number 5, resisting arrest. Your Honor, the respondent, we believe, has got information necessary to assist the police in the investigations. Given the fact that he himself has not recorded his statement, and several witnesses are yet to be traced and interviewed.
Yes.
The investigations will entail extraction and analysis by the DCI Forensic Lab of the video clip containing the several speeches made by the respondents on the 7th of September 2020.
Yes.
Further, the investigations will require the forwarding of a Seska pistol, serial number B022713 with a magazine containing 11 rounds of 9mm caliber, that were found in the respondent's compound in a motor vehicle registration number KBR 257S Toyota Allion.
Yes.
The investigations will further entail inquiring from the Chief Firearms Licensing Officer whether the said firearm is licensed and to whom.
Yes.
And the investigating officer will also need to inquire from the National Transport and Safety Authority, the registered owner of the said motor vehicle. Your Honor, the said application is supported by the affidavit attached to the application sworn on the 14th of September 2020.
Yes.
In which the grounds appearing on the affidavit are the same grounds that I had earlier listed in the notice of motion.
Yes.
And we further wish to highlight paragraph number 3.
Yes.
That the police who had gone to the home of the respondent on Friday, the 11th of September 2020, were unable to arrest him due to resistance from members of the public.
Yes.
Your Honor, it is our submission that the respondents exercises great influence on members of the public on the ground. And releasing him on board at this moment would jeopardize investigations in light of what was witnessed on Friday at the home of the respondent.
Yes.
When we submit that the respondents, after the event of Friday, had the whole of Saturday, the 12th of September, to surrender himself to the police. But he failed to do so on Saturday.
He surrendered when?
Sorry, Your Honor.
When did he surrender to the police? I missed that one.
He surrendered on Sunday.
On Sunday.
That was yesterday. Yes.
Proceed.
So such conduct on the part of the respondents puts real fear that the respondents will fail to appear in court when required to do so.
Yes.
You know, we are asking this court to take judicial notice of the fact that there have been several demonstrations against the respondents with regard to the utterances that he made.
Yes.
And the release of the respondents at this moment would disturb public order, peace, and security. Therefore, pretrial detention is necessary in light of the public response to the offenses committed by the respondents and to avoid public disorder.
Yes.
We further urge the court to take judicial notice of the several instances of hate speech within the Republic at this moment, and the effect of such utterances that threaten the national cohesion and security of our great republic, as witnessed during the 2007-2008 post-election violence in the country.
Yes.
We therefore humbly submit that we have demonstrated to this court compelling reasons to justify detention of the respondent for 14 days to enable the police to complete the investigation.
Yes.
Your Honor, I wish now to report the list of authorities which we filed together with the application. And with regard to the Constitution,
So many.
we submit that, sorry,
Yes, I've seen them proceed.
we submit that we have demonstrated compelling reasons as required under Article 49(1), F and G to warrant denial of bail at this moment.
Yes.
With regard to the bail and bond policy guidelines, we submit that under paragraph 4.9, we have demonstrated the likelihood of the respondent interfering with witnesses, given the relationship between the respondent and the potential witnesses who are his constituents in Kapseret.
Yes.
We have further demonstrated that the respondent is a flight risk for failing to surrender immediately he learned that the police were looking for him. And finally, that it will be necessary for public order, peace and security to detain the respondent.
Yes.
Your Honor, in the authority number 3, Republic versus Sebastian Militi Samuel, the main issue that was considered in paragraph 12 of the said authority is whether or not the accused would interfere with the witnesses, the nature of the offense, as well as public order, peace, and security. And in that case, the court denied bail to the accused person in light of those grounds.
Yes.
Your Honor, in authority number 4, KKK versus Republic, in paragraph number 6, the court had to balance between the rights of the accused person against the public interest. And the court denied bail after seeing the public interest outweighed the right of the accused person to be released on bail.
Yes.
We do submit that the public interest in this case outweighs the right of the respondent to be released on bail, and the court should therefore not grant bail to the respondent. Similarly, in the authority number 5, Republic versus Joktan, Mayende, and 3 others, in paragraph 25, the issue of public interest was also considered in that case, and interference with witnesses, and board was denied similarly in that case. And Your Honor, in the final authority, Republic versus Diana Suleiman Said and another, in paragraph number 17 and 18, the issue of public interest in national security and public safety was found to be a compelling reason to deny bail, and bail was also denied in that case.
You can see me?
Yes, we can now see you, Your Honor.
Yes, proceed.
And before I proceed, I would like to, Your Honor, I would like to. Sorry, Your Honor, we are trying to arrange our sitting so that we are able to properly address the court. I wanted to say that before I proceed, I would like to say that I have gotten the gracious permission of my learned senior, G. Boschole, O. Murkomen, and Isaac Ferrer to go first in response to the application on behalf of the defense team.
Yes.
Your Honor, the defense team outrightly opposes the application. And the first basis of opposition is the question as to whether the request in itself is constitutional in the first place.
Yes.
We submit, Your Honor, that this request is not constitutional under the provisions of Article 49 of the Constitution.
Yes.
Your Honor, we'll come back to that in terms of response in the points of law, but I would like to respond to the issues of facts which have been raised in the affidavit of IP James Akelo. And first, Your Honor, under paragraph 3, there is an allegation that the suspect resisted arrest on the 11th of September 2020. An averment that is false. Your Honor, it came into the public knowledge that on the 11th of September 2020, the suspect, Honorable Oscar Sudi, was not in the alleged residence, that is at Kapsere. He was not present, and the investigating officers within the jurisdiction of Kapsere were aware about the fact. Your Honor, the suspect indeed confirmed that he had, on the 10th and the 11th of September 2020, had both telephone conversations and exchanged messages with the CCIO, one Mr. Washira, where he had been told that he would be summoned to appear on Tuesday, the 15th of September 2020. At 10 a.m. Therefore, the purport that he resisted arrest is untrue. Your Honor, it's admitted at paragraph 5 of the affidavit that the suspect presented himself at Langas police station upon learning that he had been looked for the previous night by the police. Your Honor, it's important to note that he voluntarily took himself to the police station which was the nearest within the jurisdiction where he was, and he was airlifted to Nakuru, where this court is. It is therefore not proper for the prosecution to state that the suspect was in the first place arrested. Your Honor, the allegation in the paragraph that the prosecution requires time for purposes of conducting official searches for the ownership of a motor vehicle KDR 257S Your Honor, is beyond the control of the suspect. And two, that the process in itself is digital and instant. The state has not established any basis why they did not do this from the day that they raided the suspect's home on the 11th. Up to this afternoon. The presumption we can take is that the prosecution intentionally delayed so that they use it as a basis of this application. And we ask that you disregard that as a basis of denial. You disregard that as a basis of denial of bail to the suspect. Your Honor, it was equally submitted by the prosecution that the suspect has not recorded any statement and we submit that the averments at paragraph 7 of the supporting affidavit does not support their prayer. For the reason that it is now over 36 hours since the suspect was in the custody of the police, witnesses who can thus testify on such charges are not ordinary witnesses, who can be interfered with by the accused, by the suspect, sorry, should he be released. And lastly, the nature of these offenses involves publication and their dissemination, with which the suspect has completely no control over. The submission, therefore, that the suspect will interfere with witnesses should fall. Your Honor, even if we want to say then he is possibly going to interfere, it is public information now. That the suspect had a peaceful procession on the day preceding his surrender to the police. This procession was conducted in Eldoret Town and Cheptiret Town, or shopping center. And these places have got resident police stations, and the public was peaceful the entire of that time. It cannot then be that there is a possibility of public unrest should the suspect be released. And Your Honor, all these rallies, as I've said, were permitted by relevant authorities, including the police. They also provided security. And they cannot be had now to say they need to detain him because of public interest. That's to Your Honor, on issues of facts, as regards the need to conduct forensics as it's been submitted before you, it cannot form a reason or a basis for the grant of the prayers in the application. Your Honor, it has not been shown that the firearms belonged to the suspect or were in his possession. Your Honor, so that even as you consider the application that is before you, the question that this court should ask itself is to strike a balance between the liberty and the right of the suspect and the proper administration of justice. The proposed investigations under paragraph 3 of the affidavit of Akello all reads to possible charges of offenses which are misdemeanor. We hasten, Your Honor, to state that Your Honor, can you hear us?
Yes, yes.
I was
Proceed.
submitting that we hasten to submit that this honorable court should resist the temptation as has been submitted by the prosecution to be used for scoring political interest, and instead should act with a lot of restraint and strictly follow the law because the court is the last port of call for those seeking justice. it will be unjust and improper for the prosecution to depart from what they ought to have done and purport to come and use the courts to attain that which they could not get outside the courts. Your Honor, I commence by citing the entitlements under Article 49 of the Constitution. And that article is the cornerstone of the entitlement of the fundamental rights which this court can only protect. In support of that, we rely on the case of Michael Rotich versus Republic. This is EKLR 2016. Miscellaneous Criminal Application number 304 of 2016. This is the decision of Justice L. Kimaru in Nairobi. Where in agreeing or in declining to agree with the prosecution, said that arrest and arraignment of an applicant, then in that case, before court without any charge being preferred against him, was in breach of the provisions of Article 29 and the courts agreed in that case that the entitlement to bail is paramount, and it granted. As against the application that the prosecution had made in the trial court. In the present case, the prosecution has not even presented a holding charge. was stating, Your Honor, that in this case the prosecution has not even presented a holding charge.
Noted that.
Okay, thank you. And therefore they cannot then ask for you to deny bail when they have not even disclosed the possible charges against the suspect. I will ask my learned colleague, Mr. Quaid, to do on the last bit in distinguishing the authorities which were submitted before you, but I ask that this court should dismiss the application by the prosecution and grant the suspect bail in accordance with the provisions of Article 1, Article 49, 1D and H. Such bail terms should be as reasonable because of the submissions made that the suspect availed himself, will be ready to undertake and comply with the conditions that this court might set. Your Honor, I'll ask my colleague to proceed from that point. Thank you. I submit.
Thank you.
Your Honor, over and above what Mr. Sigea submitted, on behalf of the entire team, I want to submit further, based on the decision by Justice Kimaru, and in the present circumstances which were so similar to what was before Justice Kimaru, the accused person was granted bond and or bail. The police, who had no draft information, Your Honor, were directed not to arrest, not to intimidate further, not to interfere with the person of Michael Rotich. Your Honor, we urge you this afternoon to put your feet firmly on the ground and grant the accused person here, in Your Honor, bond, as the police, NCIC, take whatever time they want. You can clearly see that they are not ready. They will not be ready tomorrow. They will never be ready. Very quickly, Your Honor, to the authorities cited by my senior, Mr. Karuri. I know this is a studious court. I will mention very quickly the third authority, which was cited as the first one, Your Honor, that is Republic versus Sebastian Miriti Samuel. This is an authority, Your Honor, cited for purposes of making a timid allegation that the accused before you who is law-abiding and a legislator would interfere with witnesses. Your Honor, the touchstone at page 2 of that decision, captured very clearly in paragraph number 13, requires that the witnesses that can be interfered with are mentioned very specifically. That is paragraph 13, Your Honor. And not just specifically. Your Honor, Republic vs. Sebastian Meriti Samuel, which was cited by Mr. Karuri. The witnesses should not just be mentioned in passing, they should be very specific. The probability of interference should be so real so that, Your Honor, in a similar application, you should see the interference. And in the present case of Sebastian Meriti, Your Honor, the interference was so real. Actually, the suspect in that case had dismembered the limbs of a witness who testified in person. Your Honor, in the present circumstances, you should be extremely worried, Your Honor. You should be very worried. I urge you, Your Honor, to be very worried. Not a single piece of name of the witnesses is mentioned. And I think my senior, Mr. Karuri, this morning on his way to the railway station, found himself in the bus station, Your Honor. He must be taken back to where he should go. Who are these witnesses? You cannot tell the court that these are witnesses from Kapseret constituency. This is a constituency with about 1 million people, Your Honor. Such generic application, Your Honor, should be disregarded in as much as it's very abusive of the court process. There is a big distinction between this case and the case of the accused person before you. Allow me, Your Honor, very amply to proceed to the case of Triple K versus Republic. Your Honor, at page 2, paragraph 4 of that decision, the principles of the bond and bail policy are highlighted. I know Your Honor is very studious. Interference of witnesses is the one cited by the prosecution in this case. These are witnesses they are mentioning in Utopia. Not a single piece of name is mentioned. It is so generic. I urge you, Your Honor, to ignore that limb of interference of witnesses. Your Honor, to the final authority of Joktan Mayende, this is a decision by Justice F. Gikonyo. And Your Honor, the good judge started by defining what is a compelling reason. You will find that at paragraph number 3. More importantly, Your Honor, the issue of interference of witness came at the risk of boring this court. We do not know who these witnesses are. But Your Honor, you have to look at this in the context of the intended counts. Are these the kind of counts that the accused person can interfere with? Fire testing of a firearm? This is something that is done under very heavy security apparatus of this country. Fire testing of firearms is not even done in Nakuru. It is not done in Eldoret. This is a functionary done, Your Honor, within very serious security apparatus of this country. Same thing to confirming the identity of a vehicle. Your Honor, assault cannot be continuous. How do you interfere with investigation of assault? Your Honor, I urge you, in light of those three authorities, to find that they are in favor of the accused person. I reiterate, Your Honor, very humbly, that in the absence of draft information, allow bond with such terms, such conditions, Your Honor, as you may deem fit. And finally, Your Honor, what is before you is more important for what it does not say than what it says. This is probably, Your Honor, the beginning of pretrial detentions in this country. And Your Honor, you are a citadel of the rivers of justice. We shall be demonstrating that what we now have as a country, and that is why we are urging the court to be on guard, to be vigilant. We are seeing cannibalization of institutions by the executive arm of government, militarization of politics, and politicization of the police. Your Honor, let politicians deal with their political death outside there. Let politicians, Your Honor, sort out their issues in political rallies and arena. Please, Your Honor, safeguard this temple of justice by disallowing this sad attempt to violate the right to liberty, to violate the right of freedom of expression by using the carpet of the temple of justice. Your Honor, we shall forever pray that you dismiss this application, allow the rivers of justice to flow towards the accused and other people who are probably not on the right side of government that controls security apparatus. We are most obliged, Your Honor.
Thank you. For the respondent? Is the respondent done? Mr. Karori?
Not neglect, Your Honor.
Yes.
Yes, Your Honor, in brief response to counsel for the respondent, let me start with the final remark that the court should guard against political interference. I wish to submit that there is no political angle at all in this case. The applicant is acting in accordance with the mandate of the National Police Service Act, investigating a crime committed and the applicant believes in equality before the law of all Kenyans, no matter what social standing you may have. Secondly, Your Honor, the offenses which we intend to charge the respondent after completing investigations are not misdemeanors. They are felonies.
Yes.
Your Honor, in response, the authority cited of Michael Rotich versus Republic. I wish to refer the court to the case of Betty Jemutai Kimeiwa versus Republic.
Your Honor, I don't
2018.
know. Your Honor, with your permission, I don't know whether we are restarting this afresh. Would I have a second bite of the cherry? I do
No,
not
Your
have
Honor, I'm just
authority.
responding to the said authority of Michael Rotich, which was disregarded by a fellow judge, Edward Moredi, in the said case which I was quoting before the court. My point is that the said authority is not binding on this court.
What we are saying, Your Honor, is that we don't have the authority Mr. Karuri is referring to. It's a new thing altogether. I think Mr. Karuri would probably be guided, Your Honor, to respond to the issues of law that arose specifically in our submissions.
Mr. Karori, you want to rely on a decision of the High Court?
All right, Your Honor, I will disregard the said authority, but just point out to the court that the state authority of Michael Rotich is not binding. It is only persuasive. Further, Your Honor, the law, actually the Constitution provides for such an application of seeking time
Yes. Proceed.
Mr. Karori?
We seem to have lost Mr. Karori.
Your Honor, I can call him to do my phone so that he can address the court to do my phone.
No, you have the ability to do that.
So that in case he has disappeared, Your Honor, you would not have
Oh,
an
Your
excuse.
Honor, I'm back. Your Honor, sorry, it was my internet.
Oh, you're back. Good.
I'm back. Sorry. The internet was a bit bad on my side.
Yes, please.
Sorry, I was on the point of the Michael Rotich case. And wish to submit that our application is premised on the Constitution, that situations such as these do arise, necessitating the holding of a respondent in the custody of the police to enable them conclude investigations. It is only logical for the police to produce a suspect before the court once investigations are complete for purposes of full disclosure and certainty as to what a suspect is facing.
Yes.
As regards the submission that there were peaceful demonstrations on Friday in Eldoret after the respondents' political rally, our submission is that the demonstrations witnessed countrywide, especially by women, are what is making us urge the court to detain the suspects for the sake of peace.
He's supposed to submit on facts in a rebuttal.
It's actually just emphasizing what he had already submitted. He talked about demonstrations against the suspect, didn't you, Mr. Karori?
Yes, thank you, Your Honor. Yes, I had.
Very well done, Your Honor. I think you should then be restrained.
The only thing he has added that it was Ben Women.
You should be restrained, Your Honor.
So, Your Honor, that is all that I have to submit in response, and pray for that our application be allowed. Thank you.
We have an application to request that the accused person be remanded at Nakuru GK remand home. For the following reasons, Your Honor. Your Honor, number one, Nakuru Central Police Station, Your Honor, where the accused person has been for the last 24 hours. It is fairly congested in the estimation of the accused person and the defense counsel. Your Honor, we pray that he be taken for emergency medical treatment, and upon being given the treatment, he can go to Nakuru. Your Honor, are you still around?
Yes.
Okay, thank you, Your Honor. He can be taken to Nakuru GK prison remand home after he is gone for medication.
Okay. You done?
Yes, Your Honor, we are most obliged.
Mr. Karori?
Your Honor, we oppose the application by the defense. Remand home is for persons who've been charged. The accused person, the respondent is yet to be charged. And he will be required by the investigators for interrogation at the Nakuru police station, where he will easily be accessible to the investigators. Your Honor, we should all agree that we are all equal before the law. So the issue of congestion should arise. We have other Kenyans at the Nakuru Central Police Station, and I believe we have enough facility to cater to all Kenyans equally. Finally, we have not been told what the respondent is suffering from, that he needs emergency treatment. That notwithstanding, we pray that he be taken to the Nakuru PGH hospital, where we have qualified government doctors who can attend to any ailment that the respondent may have. That is all. Thank you.
Mr. Karori, are you willing to give medical expenses? Mr. Karori?
Yes, Your Honor.
Medical expenses?
The respondent should cater for his own medical expenses at the PGH, Nakuru, which is very affordable.
So the accused has not yet been charged with an offense. He may therefore be unsuitable to be detained at the GK prison. Secondly, these are short-term remand. Maybe by Wednesday, we shall know whether it will be extended or not. So I do not find it useful to take him to the remand home. He will be remanded at the Central Police Station. He may also be escorted to PGH for treatment.
We are most obliged. We are very grateful. Thank you, Your Honor.
Your Honor.
Starting with Nakuru Police Station. Prosecutor. Starting with Nakuru Police Station. Are you? Yes, Nakuru. Done.